Hello and welcome to everybody that is in the webinar already. We try to be respectful of people's time, have these not take too terribly long. So we try to start right on time and get them over in the 30 to maximum 45-minute time period. So hopefully we've got most folks, if not all folks, that want to be here tonight on time. But if we don't, we're going to go ahead and get started, and then folks can trickle in as they are ready. So let's start really quickly. I'm mostly going to do a presentation tonight that's going to effectively be a PowerPoint. I'll walk through a lot of information. So I'll share my screen soon, and that will be predominantly what we go through. I am open to opportunity for question. It's down at the bottom of my screen, a Q&A portion that works pretty well. If folks have questions, they can type those in there. It will notify me, and then I can take a break, answer those questions, and then get back to my presentation. So feel free to do that if you'd like. I'm definitely going to be available either tomorrow, any day after. If you have questions, you can email, give me a call, things like that. So I'll provide my contact information a few times as we go through here. My name is George Padgitt. I'm one of the partners at Sever Walker Padgitt, which is the law firm that has invited you here. Um, we're going to talk about a lot today. Hopefully some really good, helpful information that even if this is the last point of communication we have with you, which I hope it's not, but even if it is, hopefully there'll be information in there that allows you to, move forward in the process with a little bit more confidence and a little bit more understanding of kind of how this stuff works and what you should be expecting. So bear with me here for a second while I share my screen and get the presentation rolling, and then we will go from there. Okay, so we are here to talk about the Critical Energy Reliability Link pipeline. We are, again, Sever Walker Padgitt. We are a law firm that is an eminent domain focused law firm for landowners. You'll see our office phone. You'll see my direct line, which if folks are going to be interested in calling, I kind of recommend that you use the 614 number, which will go directly to me, to my cell phone. You can also email me at george@swp-legal.com, which you see there as well. Email is of course always a good means of communication as well. That way, if you call and you don't reach me, the email allows me to get back to you when I'm able and hopefully get you the information a little bit quicker in the event that I'm not there when you call. So just leave that up for a bit here for folks to write that information down if they'd like to. And then we'll get into the presentation. And this will come up back again later at the end if folks don't get a chance to jot everything that they want to jot down. So, who are we? What are we doing here? I feel like that's always a good place to start. We are, like I mentioned before, an eminent domain law firm. Our pretty much 99% of our practice is eminent domain work, and it is for landowners only. So one of the very first questions that we will get a lot is, are you with the pipeline? Why are you contacting me? That kind of those kind of questions. So we are not with the pipeline. We're with ourselves. We are a private law firm that works with landowners all over the country that are affected by projects like this. We've got many, many licenses in many, many states. Even when we're in places where we don't have a license within our firm, we've developed local counsel arrangements, which have been really good for us, which allow us to bring our eminent domain expertise to the table. And then we have attorneys locally that are there to help make sure that nothing goes awry from on a local level in terms of there might be small differences in different jurisdictions in terms of how things are done. So that is typically how we structure these types of situations, which allows us to work all over the country with landowners that need our help. We have worked in Colorado in the past a number of times. So we've got a lot of experience out there and specifically with pipelines out there. So that is another sort of relevant piece of information as it relates to why we're here and why we've contacted you. We've done ultimately, I mean, if it may be 1,000+ pipeline cases at this point, but it is definitely many hundreds of pipeline cases. So this is something that we've got a lot of experience with. And so tonight we're basically going to be discussing a little bit about the project, although that's not where we're going to spend the majority of our time. We're going to talk about eminent domain and sharing some insights. I'm going to give you some what we just think is good information, what to expect, how you might want to handle it, things you should be considering, all that kind of good stuff. So let's get started. Like I said, we'll knock out some information about the project, but we are not experts on the project. We're experts on eminent domain. So um, you'll see a map there of the general path of the project. I mentioned earlier that we worked in Colorado before. One of the major projects that we worked on is the Cheyenne Connector Pipeline, which is, you'll see at the very top of that picture where this new pipeline connects into that line. So we did a ton of work in Weld County and the county north of it, I believe. And that was a few years ago now that project was making its way through the FERC process and we were negotiating on behalf of landowners. So this project latches onto that, heads south for about 150 miles of pipe. Um, these projects are governed by FERC in the big picture. And so FERC is the Federal Energy Regulatory Commission. It is a federal agency whose job is effectively to regulate these types of infrastructure projects, natural gas pipelines, not exclusively, but pretty specifically. This project's currently in the FERC process. They filed for their what we call their Certificate of Public Use and Necessity, which is effectively the permission slip for use of eminent domain for construction of their project. So that is in the works, although still not at the final stages by any stretch. Although that process doesn't always take forever. I think they filed it in sometime in the August window, so they're moving that along, but there's still a bit of process there in front of FERC. And like I said, there you'll see the last point. FERC approval equals eminent domain authority. So when that FERC process is completed, that is when they then have the ability to, if they get that certificate, to potentially use eminent domain to acquire properties or easements across properties where they were not able to successfully negotiate for those easements. So that tells you a little bit about the project and how it's being overseen. And I can't give, unfortunately, any specific timelines on what to expect in terms of the project being final through the FERC process or in construction or anything like that. We don't get special information or insider info on that stuff. We've got the same generally publicly available information as anybody else. So, all we know for sure, it's in the process. Typically, when it's in this process is when we're able to do the best work that we can do for landowners, which is a big part of why we're reaching out to you now. So if there are more questions about the project itself, happy to answer those, but those are going to be well suited for like an email at some point in the future. If you want to drop me a line and ask other questions, I'll be happy to try to give you as much information as I can. So now we know what the project is. What happens next, right? So there's definitely steps between now and eminent domain, as I mentioned, but ultimately eminent domain is what we're staring, down the barrel of. And so eminent domain is a process, effectively. It's generally an idea, and we use certain laws and there are statutes and things that allow us to sort of understand it and put it into practice. What is it? It is effectively the power to seize private land and put it to a public use. So the most classic example of that isn't going to leave anybody confused is, there needs to be a new road to open up, access to communities. And so they take private land from citizen landowners in order to have the space to build that road and allow the folks in the area to connect where they need to connect to. That is typically road projects specifically, or typically the area where folks tend to generally understand and not question the use of eminent domain. I think there's a bit more questioning of the use of eminent domain when we start to get into things like these energy infrastructure projects. I'll talk a little bit more about that later, but it can be used for things like natural gas pipelines. We've sort of established an energy system that's reliant to a large degree on things like natural gas, and so for many years and decades, courts have interpreted transportation of these types of materials as a public use that is beneficial to the public at large, and therefore eminent domain has been usable in that sense for quite some time. So the big caveat here with eminent domain, or the landowner part of this, what do you get from it, is what we call the term just compensation. So uh, really granularly, that might mean different things to different people, but in the big picture, essentially what that's supposed to mean is payment for your land and any impacts to your land that the project causes. So you can think of it as you should be put into the same position financially as you would have been had the project never happened. And so that's difficult. It's a little bit of a moving target. It's not an exact science, unfortunately, but that is the goal, and that is their obligation to you. And that is what a big part of our role and a big part of what you should be aiming to do is to hold them accountable to their obligation, right? Because they will come show up. And for those of you that have already had some communication with these folks, because I understand that there are some people that have and some people that haven't, they will they're really focused on what they need and what they want and what they're trying to get. And they will talk to you about what you get, but you need to make sure that as part of your process, you are holding them accountable to what they owe to you from this process, which is just compensation. Um, and what the process generally looks like is at some point they will come to you and make you an offer. This is like a pre-condemnation offer, so it may be under threat of eminent domain, but there is no eminent domain in play. They're simply saying, here's what we need to do, here's what we think it's worth. And that's kind of the starting point for where things really kick off in terms of the acquisition of your land. Once those offers are in hand for landowners, that is typically when a firm like ours, any attorney that does eminent domain, frankly, will get involved. Um, Mainly because prior to that, there's not a lot of help that can be provided in terms of negotiating additional compensation or negotiating easement language, putting the landowner in a better position than they would have been otherwise. That's not available until the process is really underway. There may be, in certain circumstances, folks who pool some resources, or sometimes, I guess, really determined folks who might try to handle this on their own and fight the actual process and try to kill the project and things like that. But that is not typically where at least our firm is putting our effort. It's usually not very successful, nor is it easy, nor is it cheap. And so our focus is typically on helping folks once they get to the point where they've got an offer in hand and trying to maximize the process for them at that point. There obviously can be negotiation prior to or post receiving that offer and prior to other things happening. That's our goal, right? For the folks that we're working with is to try to take that offer and figure out how we get it somewhere where everybody feels really good about it. Everybody on our end, that is. If that is unsuccessful or that doesn't result in some kind of deal with the pipeline, then you may end up in a condemnation lawsuit, which is sort of the next big step in that process. As you'll see here, that can only happen once they have their first FERC certificate. Said that earlier. That's kind of the trigger point for them being able to use that power for this specific purpose. The FERC being a federal agency, that puts them potentially in federal court. We've seen with larger pipelines, more often than not, they elect to go the federal route. It's a little bit faster typically. It's a little bit simpler for them typically. And as you'll see at the very bottom, there's no guarantee that you get a jury in a federal court, which they like, because at the end of the day, a jury is, probably most of the time going to be more sympathetic to the landowner than they are going to be to the multi-billion-dollar corporation that's trying to slap a big pipeline on everybody's property when those people don't want it. So ultimately, if you can't figure something out, you end up in court. And then ultimately, if you can't figure something out while you're in court, you get to have a trial on your just compensation. So that could be, depending on the circumstances, to a jury, could be to just a judge, could be to a panel. Sometimes in federal court, there's a panel that gets put together to hear these cases. So there's there's a little bit of variability there, but ultimately the process is aimed at they have to make an offer. We see if we can figure it out. If we can't, you get into court, you get more chance to figure it out. If you can't do that, you get a trial. Now, what do they really want? They want an easement, and I don't want to insult anyone's intelligence here, but we are often hearing from people who may or may not actually like really understand what an easement is and what it does. It's not necessarily imperative that you do, particularly if you get help. That's part of, what we're here for. But hopefully this will be a little bit informative in terms of what this really is and what you should understand about it. So if they came to you and they said, we need to buy your land from you in what we call fee, which means we need to buy all of the rights, including the right of ownership, because we were going to build something here, like a building, right? Then that would be really straightforward. You understand what you're selling, they understand what they're buying. It's clean cut when that's all said and done. But an easement is a little bit different. An easement is effectively still a deeded transfer, but it is a transfer of only some of the rights that you have as fee owner, full owner prior to the acquisition. You're only transferring a portion of the rights that you have. Now, obviously, the biggest thing you're transferring is really control of the area. So, you don't maintain the majority of the rights. In most easements, they are going to take most of the rights, but you will maintain some of your rights, including ultimately your right of ownership of the, underlying fee. Um, the an easement can be very simple. An easement can be very complicated. But ultimately, that document that you end up signing at the end of the day, or that ends up being granted by the court, if that's what it comes to, is going to dictate their rights and your rights to that portion of ground moving forward. So it'll say what they can and can't do. It'll say what you can and can't do. It will typically have some provisions that address, future issues, disagreements. Really, if there's usually some major things that everyone knows are going to potentially come up. Those are usually addressed in the easement. So it won't be exhaustive, and it's not meant to be, but it is meant to do the best it can to outline the nature of that relationship once the easement is in place. So if you got questions, will they be allowed to do this said thing on the easement? That really depends what the easement says. And we've talked a little bit, or we will talk more about compensation. We've mentioned the compensation prior to this in terms of just compensation, but through doing this for a number of years now, we've really, I think, gotten better with the easement. I think it's probably just as important as compensation when you really get down to it, because the easement lives on effectively forever. It will run with the land. So this land passes down to future generations. That easement stays in place. Those future generations will be beholden to whatever deal was made now. So it is really important. So we try to negotiate that the best that we can, clean that up, leave no loose ends if possible, but as few as possible, so that the relationship's perfectly outlined and there just really doesn't need to be a lot of stress about when things happen in the future, what's going to happen. Um, Now, what you're told by people like right-of-way agents, or even by people from the pipeline, or really from anyone, is not necessarily what the agreement says or what the easement says. Yeah, those things have to align for what you're being told to be true. So be careful when you're talking to other folks about what the pipeline's going to do or what their obligations are or these different things, because if it's not in the easement, you can't be certain that that's part of the agreement, or that is an obligation of theirs. So you really want to, that's another reason why the easement's really important. Here we have a few potential pitfalls If you're not negotiating this easement correctly, you're not paying attention, and you're not putting in the work on the front end there, you could end up with a situation where they just have unlimited access to all of your property whenever they want, not necessarily to put the pipe, although that's worst case scenario, but in general, you could have a situation where they show up later, into the future, wreak havoc, cause a bunch of damage, and they might not be on the hook for that if you haven't addressed that in the easement. Restoration of ground is a really big part of pipeline easements. They dig huge ditches, they disturb tons of stuff. When we were out there previously, we were, dealing with irrigation ditches and, native grasses and all these different things that folks wanted to see happen when it came to restoration. And without clearly defining that in the easement document or in some part of the agreement, you're really going to be running the risk that those things are not handled the way that you'd like them to be, or they need to be handled. There's liability issues that, we try to get as clean as possible within the easement language, clearly indicating that landowners don't have liability for the pipeline. It's not yours, it's theirs, and it's their problem. And then also you really want to make sure that they've only got the right to put in one pipeline. They've only got the right to do what they need to do in relation to that pipeline, that they don't have power to grant access to random third parties to use the easement for different things. You really want to make sure that you're granting the least expansive easement as possible, the most restrictive easement as possible, is a better way to say it. So those are things to be keeping in mind as you consider your easement and what's important. So that's half of the situation. The other half is compensation. So what does compensation typically look like, in terms of what are all the pieces to that puzzle? And sometimes it can be a puzzle. It is sometimes very simple. We're talking about a certain price per acre, and that takes care of it. But sometimes it can get way more complicated than that. And more often than not, it is more complicated than simply one price per acre. But the first part is price per acre of the ground that's being occupied by the easement, right? We always, that's 101. We got to cover they're taking 2 acres. 2 acres of your ground is worth X, right? But then on top of that, there's all kinds of other impacts and, damages that can be part of the equation. So you'll see here, it could be crop or timber damages, soil damages, remediation expenses. A lot of times, even when you have a really clearly delineated process for them to maintain your soil and then restore your soil, we still find that a lot of our landowners feel like they need to spend additional money and additional time and effort to really make their land viable again, or get it as close to as possible, to its prior condition. So that can be part of the process. Um, there are a lot of other things, not even just soil quality, but specifically with, let's talk about if we've got pivot irrigation, there can be real problems with that, at least temporarily. If there's compaction of the soil after the fact, that can lead to standing water. It can lead to low spots. It can lead to issues with soil like production. So there's a lot of things that can happen that are problematic and that we need to address in terms of making sure that the compensation package provides for all of those things. Residual damage is really a catch-all term for all of those things and any other way that this impacts your property. One of the biggest things is that, typically, if you've got a property that doesn't have any easements on it, any major infrastructure easements, and then you get a major infrastructure easement, there's at least a presumptive, you know, there is a presumption that that is now an inferior piece of property to property out there without any easements, right? So residue damage could just mean the rest of your property is worth a little bit less than it was before, because now that you have something that is not the same as what you had before. The classic example that we will sometimes give is a plain white piece of paper might be worth 2 cents to somebody, but if you draw a big black line through it with Sharpie, it's worthless, or it might only be worth 1 cent to someone because they're going to use it for a totally unrelated purpose. So that's what we're trying to capture sometimes with residual damage is how much is this affecting the overall value of the property. at the end of the day. And then sometimes there are other payments that just make their way into the process. They're not necessarily going to be tied to anything specific, but you might see them offer like a 10% bonus if you do X, Y, or Z, or if you agree by this date. Like those things can obviously be part of the equation as well and utilized to get us to a point that everybody feels good. Sometimes those are a part of it, and sometimes they're not. So, right away agents, that's the first, probably the first point of contact that you folks are going to have with the pipeline, quote unquote. Here's what we just want to tell folks about that. They can be tricky. That can be a tricky process. You really want to be careful. They're going to focus on lots of different tactics effectively to convince people that their offers are good and that they should be accepted. And their job is to kind of get you to sit down at the kitchen table and sign the dotted line. You got to be careful about that because contextually, what they're telling you might be great. It might also be nonsense, right? If they give you 150% of what they've determined to be fair market value, but they've determined fair market value to be 30% of what it should be, you're still nowhere near where you should be. And so 150% might sound great, but it doesn't mean much. Same goes for bonus payments. That doesn't mean that they're in a good place just because there's some extra money on top that they're throwing in to try to incentivize you to sign the deal, and give them what they want. So be careful about those things. Be careful about basically anything that right away agents tell you to a large degree. They're known for making kind of verbal commitments, whether those are offers or different commitments, and then all of a sudden, a week later, you've got a new right away agent who doesn't know anything about that and can't vouch for what the previous person said and isn't able to honor whatever you were told. So just be careful when you're dealing with these folks. You really want to put yourself in the best position that you possibly can to utilize you'll see leverage, and leverage equals money. You want to put yourself in the position to use your leverage the best way you can, which is how you're going to get the best results. And having a bunch of conversations with the right of age and telling them everything you think and trying to be fair because you are fair people and you want everyone to be fair is not always the best way to handle this because they don't really have a lot of intention always of being fair with you. So if you're not sure, if something feels not quite right, you want to get a second opinion, ask me. Send us an email, give us a call. We are happy to walk you through it and make sure that you guys have a level of comfortability with what you're experiencing. And we've got plenty of experience ourselves with this type of situation, so we're a good resource for that type of stuff. So real quickly, try to fly through these next couple slides. What should you be doing when you receive an offer? It's really smart to try to get whatever communication you can get in writing, so that there's no wiggle room on it. We really recommend that, again, that folks don't sit down and chop it up with the right-of-way agent over a cup of coffee for hours. It's not that that's necessarily always going to hurt you, but it's just really not going to help you, and frankly, much higher possibility that it ends up being something that you wish you hadn't done than that you're happy that you did. Let me put it that way. So, a really easy way to handle this is when you get your offer. Hey, thank you. I'm going to be back in touch with you in a bit. You know, a week or two. I'm going to take some time to review this. I might have somebody look at it, kind of thing. And then you're under no obligation to be in constant contact with these people or to, answer the phone when they call. This next part, I try to be careful. I know that some of what we do here is going to sound a little self-serving. It also doesn't mean it's not good advice, though, right? To be fair, it's important to get help here, to understand the situation, talk to people who know what they're doing. So whether it's us or somebody else, we really suggest contacting an attorney to review your offer, give you a good idea of what they think is going on there and how close or far away you might be from where you probably should be. And so those are some things you should do. Things that we would recommend that you do not do. The first one is kind of a repetition thing, so I won't spend much time on it. Really, the second one is kind of important. A lot of people want to problem solve immediately, and that makes sense, and we can understand that, but hiring the right appraiser with the right experience and the right credentials, that all matters very much in this type of process. So we do not suggest going straight out trying to determine your own value via an appraisal and spending that kind of money that takes. It's usually not going to be very worth it. And it's definitely something that can be done later in the process where it will be much more worthwhile, especially if you've gotten yourself in a position where you're getting the right help and getting hooked up with the right appraisers who can really help you. Um, Again, you don't want to be the right-of-way agent's best friend. It's never going to suit you very well. Don't really take all the things that they say verbally to heart. Always have a healthy amount of skepticism and make sure that you're double checking and clearing everything multiple times and getting things in writing. Like I said earlier, don't assume they have your best interests at heart because they don't. They might say that they do, and they might say they want to do certain things, but ultimately, the only person that has your best interest at heart is you. And then hopefully, if you hire someone to help you, they will at least have an aligned set of interests that will reflect your best interests. And ideally, they will have your best interests at heart, but you really want to make sure that you don't assume that the utility does. And lastly, there's no reason to make a super rush decision. We know that sometimes people will see a certain amount of money in front of them, and that will be very enticing for various reasons. And we can certainly understand that. We're not telling anybody what to do at the end of the day. But take your time, make sure you make the right decision. You really only have one chance to tackle this acquisition, and so doing it the right way is important. Some questions that we will be asked commonly. Do they have a right to survey my land? Like, what should I do if they want to come out and do surveying? We frequently are talking to and working even with folks who will deny survey access. But the reality is that this issue's been settled many times in the courts and in the legal world. They do have a right as an applicant, even just for the power of eminent domain, to do survey work, so that they can understand whether they actually have a project and what it's going to look like, and has really just kind of been determined to be a fundamental part of that process. So ultimately, we really don't suggest putting up an enormous fight with surveying, but we also try to take that on a case by case basis. Ultimately, they will almost certainly be granted the right to survey, though, no matter how much opposition is put in front of them. So, how do you find out if you already have an easement? This is one of those questions that sometimes people get curious when something like this is happening. It also can be relevant to what this might be worth and what you might want to, need to know about your property and how it affects your property. That those are matters of public record. 99% of the time, it is possible that certain easements would be unrecorded, but that's a mistake on the easement holder's part. So most easements are recorded. So you can look in your county records for that kind of information. How do I find out how much land they want and where the pipeline will be? That is really, unfortunately, not something anyone can say for certain until they show up and say, here's what we're going to do and here's what we think it's worth. So you really have to wait for the offer on that. But if you do have existing easements, as it says here, you can have some degree, not certainty, but like there's a probability that they'll be running near those other easements. That's just typically how it's done. Although, like I said, not a guarantee. What if I'm never home? That's meant to be, what if there's no good time for them to reach me? How are they going to get this stuff to me? If they can't reach it, they might send it certified mail. They might deliver the offer in a way that gets to you no matter what. So like basically some type of signature required mail service. They also might just be so persistent that they find you eventually, even if it's just to hand it off to you. And then the last question, this doesn't come into play very often, but just so you guys are aware, if it does go through a structure on your property, if this impacts a permanent improvement, you'd be entitled to compensation for that. Although that is exceedingly rare in our experience. They really try really hard not to do things like that. Very complicated, makes their life a lot worse. So they do their best to be in the open space. Now, they might be pretty close to improvements and things like that, but that's more of a compensation issue at the end of the day. So you don't have to worry that they're going to take buildings from you or things from you without paying you, but whatever they do, they just have to pay for it, is really the simplest way to put it. All right, it looks like I got the first question, so it's easier for me if I pop out here to see these questions. The question effectively is, can they piggyback off of someone else's easement, or will they have to do their own easement? And the simplest way to put that is that unless somebody in the past signed a really horrible easement, one landowner, a previous landowner signed a really horrible easement, they're definitely going to need a new easement. And the truth is, even if something like that did occur, unless it was an easement that they held that Rex or Tallgrass held in this case, they would probably not piggyback off the other. It's is almost certainly going to be new easement for everybody that is affected. But that is really, you won't know for sure until you get there. But I do think you can be like 95 to 99% sure you're going to be talking new easement when this offer finally does roll around for those that haven't received one already. All right. So this is the part where I'll just tell you, this is how we work. If there are folks that are interested in communicating further with us and potentially working with us, this is how we structure our compensation so that we can hopefully meet the needs of landowners and also, be compensated in a way that we feel like is fair for what we do. So we work on a contingency fee, excuse me. And what that means is that we take as our compensation, as our payment, a portion of the value we add for our clients. So if something horrible happens and this never happens, but something really bad happens and we just don't get you very much more money, we just don't get paid very much at all. If we do great, we get paid handsomely, but you also benefit a great deal from that relationship. So here's the nuts and bolts of it. Let's say someone has a $10,000 offer. They end up with a $50,000 settlement. So there's 40,000 in new money. We take 33% of the new money. So the landowner in this situation ends up with almost $37,000, which is reflective of the original 10, which was never going to be part of what we recover, never part of our equation, plus 2/3 of the 40. So plus another 27 or yeah, plus another $27,000 effectively. So we do this for a number of different reasons. The first reason is because there are a lot of folks that would either deem it to be not a very good risk to pay us hourly and risk paying lots and lots of money in hopes that there is more money down the line. Which obviously there is no guarantee. We don't do this because we're not successful. We do believe that we'll be successful, but there's no guarantees. So there's a certain amount of cost benefit that has to be kind of put into play there. And secondly, working in this way as it relates to specifically what we do works really well because it aligns our interests. It puts us on the same team as you in terms of our goals, right? I think that one of the challenges that traditionally hourly attorneys have in a world like this is that they are not incentivized to work for you in an efficient and effective, manner. They're incentivized to work for you. So if everybody hired us hourly, we'd constantly have this little bit of tug of war of like we can't get this figured out too quick or else we don't make any money, kind of thing. I think we're very lucky not to have to deal with that. And so, the contingency fee allows us to share in the potential reward, share in the potential risk, but it also allows us to be very honest with you and give you our genuine opinions and our genuine beliefs when we come to you and say, okay, here's a potential settlement point, or this offer is not good enough, or here's the things that you should be considering, or here's how we view this from a cost benefit perspective. So that same team element has just always been really positive. And so that's why this works for us, right? It allows us to work with more people too. We would have a fairly limited client pool if everyone had to have a big war chest just handy to pay us to go through the process, in hopes that, like I said, it's going to end up great. So that's how we do it. That's why we do it. And it has always worked really well for us. It's the best method that we found for doing what we do. If there are more questions about that or any other elements of our representation, we can talk more about that. The only additional thing that I'll add, it wasn't on the slide, but typically our contingency fee is going to be one of the only things that people are going to have to factor in. The exception to that would be if things get far enough down the line. I mentioned appraisals earlier. Those can become necessary, and those are third-party experts that they're not part of our firm. They're not, and in fact, they can't be. If they were, that'd be a problem. So because they are a completely third-party, sort of unrelated element to us, that is not part of our contingency fee. But there are really very, very few other potential costs that would not be related to you hiring an expert. So 90 some percent of our cases that don't have an expert don't have any additional costs. So just so you guys are aware of that. And like, again, if there's other questions about that, we can address those. So in an effort, like I said, to keep this into that 30 to 45-minute range, which we're doing a decent job of. Here's kind of where we wrap up. You'll see my contact info on there again if anybody does want to get in touch with me either tomorrow or into the future. Um, a few final thoughts. Whether or not you hire an attorney, whether you or not you hire us, whatever you do, if you've got an offer, you should be having somebody look at it, and that somebody should be an attorney that has experience in the eminent domain arena. You would be amazed how far off they can be, right? So you really want to make sure that you're not leaving huge amounts of money or significant easement related concerns on the table because you didn't do, something that is fairly simple, which is picking up the phone or typing an email address into your computer and asking a few questions. So, I hope folks take that to heart. There's no obligations or anything like that if people want to talk to us again, or talk to anyone else for that matter. I assume there would typically be no obligations there either. But it really is something that you probably should be doing. In the meantime, if you're going to try to help, spend some time figuring out how you want to attack this, if you want to talk to attorneys and different things like that, that is certainly a worthwhile use of time prior to having an offer. Um, Really, you want to identify your priorities and your goals. For some people, it's all about money. For others, it's all about the easement. Both are equally valid. The truth is, the typical resolution is going to be a combination of both, no matter how you swing it. So, really trying to identify what's important to you, having those priorities in line when you come to somebody really helps that person, whether that's us or somebody else, to be able to put a clear plan in place and try to get you where you need to be. We have found over time, and this was true in our experience with the pipeline just north of this one, there is a real honest strength in numbers. We found that when folks work together in some respect, or when more folks hire attorneys, you tend to see better results. It's really easy for these companies to just sort of try to steamroll a couple people, but if they've got, what ends up being a pretty significant portion of the landowners working together and forming a united front, that can be really, really valuable in terms of getting the right results here. So yeah, like I said, ultimately, if anybody has an offer, they want someone to take a look at it, I'd be really happy to do that. You can send it to me via email or you can give me a call and we can figure out how to get that handled. Also, just open to any other questions that people might have. Email or phone is fine. These meetings are just meant to hopefully get some good information in front of people and kind of start the conversation. So hopefully folks feel like there was some good information here. This is probably where I'm going to wrap it up. So I hope to hear from some of you folks in the future. Just please let us know if there's anything we can do for you. All right. Thank you. Good night.